Okay, we'll go ahead and get started. Welcome to today's webinar on leveraging homeless courts and care courts to support individuals experiencing homelessness, mental illness, and substance use disorders. And we are presenting today's webinar with the support of the Substance Abuse and Mental Health Services Administration. And our presenters today are Levana Adato and Hans Pauling, and I will introduce them shortly. And I'm Dr. Melissa Stein, a Senior Project Associate with Policy Research Associates and SAMHSA's Game Center. And you'll see a chat box icon at the bottom of your screen. Feel free to use that chat box to introduce yourself, share where you're joining from. I am joining from North Carolina. Before we start our presentations, I have a few introductory items to review. First, the views, opinions, and content expressed in this presentation and discussion do not necessarily reflect the views, opinions, or policies of the U.S. Department of Health and Human Services. If you have questions for the presenters or in regards to the technology, please type them in the Q&A pod. The Q&A icon can be found at the bottom of your Zoom platform. At the conclusion of the presentations, we will address as many of your questions as time permits. We'll also have a couple of polls pop up throughout the event, and we really appreciate your participation. Simply select and submit your response. And you should have just seen our first poll pop up. We are recording today's webinar, and the slides will be disseminated to everyone who registered for the event. We will also notify you when the recording of this webinar is posted to SAMHSA's YouTube channel. And a certificate of attendance will be available for download at the end of today's webinar. Please note that this certificate is for your personal portfolio, and we are not able to issue CEU credits. We have arranged for ASL interpretation and live captioning today. Our interpreters for today are McKenna Garassi and Wanye Jefferson. There's also live captioning for today's event. To view live captioning, click the Show Captions icon at the bottom of your Zoom platform window. And now I'd like to briefly introduce our speakers. Hans Pauling, Esquire, is the Director of Affiliate Services for the Fifth Circuit Solicitor's Office in Columbia, South Carolina, where he is also an Assistant Solicitor and Circuit Pretrial Director. A South Carolina bar member since 2000, he brings more than 2 decades of experience across public service and private practice, with work spanning prosecution, indigent defense, disability rights advocacy, and specialty court programming. Mr. Pauling has previously served as staff attorney with protection and advocacy for people with disabilities and a public defender in Richland County before entering private practice in Columbia. He joined the Fifth Circuit Solicitor's Office in 2009 and has held a range of leadership and courtroom roles, including criminal domestic violence and magistrate court prosecution, homeless court prosecutor, nonviolent prosecution team leader, deputy director, and director of affiliate services, and assignments in family court, mental health court, and Kershaw County Drug Court. His work on Columbia's homeless court earned the 2020 South Carolina Municipal Award in Public Safety, and he remains active in community and professional service through the Richland County Criminal Justice Coordinating Council and Transitions Homeless Center in Columbia. He regularly teaches and trains justice system partners on diversion, expungement, and related programs, including magistrate and victim advocate trainings and statewide conference presentations. Levana Adato is a Ventura County Clinic Administrator with the Forensic Division. She presently manages the civil programs that include the CARE Act Court Program, ASSIST, which is Ventura County's Assisted Outpatient Treatment Program, and the Adult Residential Program. Ms. Adato has been a clinic administrator with Ventura County since August 2023. After assisting with the development of the CARE Act program in conjunction with the county, community stakeholders, the court, public defender's office, and county council office, Ms. Adato was able to double the number of assist clients that the county serves. Prior to joining Ventura County, Ms. Adato was the specialty programs manager with Child and Family Guidance Center. She managed 3 different programs that included multisystemic therapy, the MSW internship program, and the case management program. Ms. Adato earned her master's degree in social work from Washington University in St. Louis and her bachelor's in social work from Tel Aviv University, Israel. So you know who's going to be presenting to you today. So I'd now like to take a moment to look at our poll results and see who is joining us today. So thank you so much to all of you who participated in our poll and who are introducing yourselves on the chat. We really appreciate that. So just taking a look at it, it's about 55% of you are joining from urban locations and a pretty even breakout between suburban and rural locations. And we do have a few folks coming who live on tribal lands, such as reservations, Pueblo, or Alaska Native villages. And then in terms of your organization or agency background, the largest proportion of you are joining from government and policy, about 23% of you, closely followed by 22% of you joining from a community-based provider agency. We also see several of you joining from the judiciary. I would expect that. And then we also see a wonderful representation from corrections, probation, parole, as well as our public health sector. Thank you so much to all of you for your time today, joining us for such an important topic. Without further ado, I'm going to turn it over to Mr. Pauling to begin our presentations. Mr. Pauling. All right, now I'm going to stop you and say that you're on mute.
Yes, sorry about that. I did want to welcome everybody. We're going to talk about homeless court today. It's going to be specific for Columbia, South Carolina, but at the same time, I'm sure you might find some useful items in there that could be applied in other jurisdictions. So let me go ahead and get started with that. Again, it's a voluntary program. We've had it in effect here since 2015. We just had our 10-year anniversary. The building in this photograph is actually the day room of Transition Center. It's located in downtown Columbia, and it's sort of an interior building. There's a wall around the whole facility. It used to be a Salvation Army place, and then in 2011, it became a homeless shelter. And over the years, it's developed programming inside, so we use that as our non-traditional setting. Again, the treatment and rehabilitation can replace court sanctions, but just from my own experience over the last 9 years, we do not follow a traditional treatment court model, so that's really important. When you do create a homeless court in your community, you probably will focus on most of the things that we focus on, but not everything that a drug court or a mental health court or a DUI court might focus on, because most of the individuals who come into homeless court, they've already engaged in treatment services. They're already connected to a case manager at any of a number of local providers, and this actually helps to facilitate homeless court and their ability to finish the program and graduate. This is the start of the program. You can see all the way back 20 years ago, they started talking about treatment courts. And then in 2013, there was a real conversation about homeless court. Nelson and Mullins is one of our private attorney firms here in Columbia. It's one of the largest in the state. And they had a gentleman who worked there named George Coffin, and George was really passionate about homeless court. So he really got those conversations from, around the dinner table to above and all the way up into the Supreme Court. We use the City of Columbia Municipal Court And I'll explain later why we did that. And again, we went through the Supreme Court of South Carolina to establish this as a specialty court. In South Carolina, the treatment courts are not necessarily statutory. So you have to create an order for the Chief Justice to sign, and that will then create the specialty court. So, unlike some states where you might have a specific statute, we do not have that here in South Carolina. 2015, we had our first session. Again, that order signed by our former Chief Justice, Jean Toll. And after that, we started to build other homeless court programs in different municipalities. So I did see in the little questionnaire survey that 55% of you are from urban areas. So these markings on the map of South Carolina, these are all urban areas. Nothing rural here. Charleston, obviously, most everyone knows that Charleston is a rather big community. Greenville and Columbia, those are the big three with Myrtle Beach and Florence. But Myrtle Beach, when we did the training there, it was actually set up under the city prosecutor's office. So it did not fall under the solicitor. Most of the other jurisdictions, the solicitor has the authority over all the prosecution. So you can do almost anything you need to do to make sure that the program is beneficial for the participants. That includes the reopening and dismissal of old convictions that may prevent them from finding a place to live, from being able to maintain a driver's license, or from getting a job. Program eligibility. We have an application that is sent in usually from one of our service providers. Right now, we have 12 to 14 referral sources. This includes transitions itself because people stay there and they connect with case manager. Case manager says, hey, you have this problem with your vital records. You have an issue with your criminal history. You have these tickets that led to your driver's license suspension. We need to try to fix these things. And I can tell you all, that's exactly what homeless court is for. That's what we're doing there in Columbia. We are fixing legal problems for homeless people to help them maintain stable living or have their best life. And for those of you who are in the judiciary or in law enforcement, everyone here who works in the legal system, there are certain things a judge and a public defender and a prosecutor can do when they all agree on it, right? And we take full advantage of that. So everything we do is generally by consent order. There's no debates in homeless court. There's no arguments in homeless court. No one has a bad day in homeless court. We're just trying to figure out how can we help John Smith? How can we help Susan Smith get to where they need to be, whether it's get a driver's license back or get a better job or maintain some more stable living and situation. So the program eligibility is very flexible. The provider screening is done at the case management level, and we do have social workers at the library, along with other transitional facilities, whether it's mental health or substance abuse, and they can all make referrals. Of course, we do get referrals from the court itself, just not as many as people would think. Again, due process, they're represented by the public defender while they're in homeless court. We do the review, supportive services, obviously, and alternative resolution. All of these things we make full use of in the Columbia Homeless Court. Now, these eligible offenses, this is like the original list, okay? So the original list was from 2015, 2014. I can tell you we've broadened it significantly, but it still works in that 30-day area. So 30-day summary court offenses in the city of Columbia. However, we've been able to branch into the local magistrates within Richland County and sometimes also in Kershaw County. So if somebody comes to us and they have some stuff on their past that they can't get expunged, but they want to see if they can get it removed, we will do a consent order to try to reopen and dismiss the case to put them in a better position. So I don't want you to look at eligible offenses and marry that, because I can tell you right now, we have evolved significantly. We will do assault and battery third if we have communication with the victim. And every time we've done that, the victim has always been very supportive of it. We do not do DUIs. That is basically a policy thing. very uncomfortable for the prosecutor to deal in DUIs when it comes to homeless court. And most of the time, they don't have DUIs, right? Because they not having a vehicle at all, or they're living in the community and they move into transitional housing. They don't have a vehicle. So we don't usually deal with any DUIs or domestic violence. But again, summary offenses, either in the city of Columbia or within the county, we will try to work with them. And our judges are great because they just want to figure out, okay, how can I help this person? And we send them the order and tell them, this is what we would like you to do. And the judges usually are fine with that. Next one. Okay. Again, the referral, the screening, the eligibility. These are all photos that mostly come from clinics that we've done. The court hearing is very, very informal. So you can see the gavel under item 6. We don't use a gavel. And the judge will wear a robe, but it's just very informal. We don't want anybody to feel like something bad can happen in the court, and nothing bad ever does. And then when it comes to resolution, that is basically the graduation. So at the graduation yesterday, we had homeless court yesterday. We had 2 people out of the 8 that graduated yesterday. Both of those people had found permanent housing while they were in homeless court, and that was what they wanted. So that was their goal. And then they also had some traffic tickets they wanted to clear up because they had fairly high fines that they were going to have to pay, and they hadn't been driving for years. So we wanted to get them back on the road legally so they can get insurance and they could have a job. And a lot of employers will not hire you if you do not have a valid driver's license. So we work with that. We try to figure out a way to make that happen. And of course, yesterday was a good day for us. We only have homeless court once a month, but we did introduce probably 14 people. We updated another 10 or 12, and then we graduated 8. So, you're impacting about 30 to 40 lives every month throughout the year. We do 11 months out of the year, not 12. This is one of the graduates. This is Inside Transitions. And this was actually at our 10-year anniversary, which was in October of 2025. These are my numbers here that we ran from January of 2018 through April 2024. Now you can look at this chart and it looks like it's all over the place, but the truth is in 2022, we had an exceptionally high graduation rate, but we had low application numbers, right? Like introduction. So the application people fill out. The introduction is when they connect with the public defender, they reviewed their criminal history, and they try to figure out, what are we doing for you in homeless court? What can we help you with? So at the introduction, that's when they are basically brought into the court. Some of them have pending charges, some have no charges. We've helped people from different states who just happen to be in Columbia and said they were trying to find a way to help with Texas, trying to find a way to help with North Carolina. So we don't really turn people away, even if their issues are not in South Carolina. The public defender will still try to work with them and see what they can do, whether it's a letter of support, whether it's just making a request for records, something like that. So 2022, you see 83% completion rate, and that's the graduation rate. And then it kind of steadies out in 2023 and 2024. But you can see that the introduction numbers really climbed, like 90 people more in the next year. And that is because the referrals really started to come in from other providers. So if you do a homeless court in your area, if you have the facilities or you have the ability to do the treatment, then I can tell you, you're going to get a lot of referrals after a while. We had been in operation for 7 years in 2022. And now, just in the last 3 to 4 years, it's really taken off. So we're very excited about that. This is a picture of myself in the center of attention, I guess. But that is Judge Jeffries, tall in the back, and Jack Jackson, who also works with me. This is also at Transitions. And that's the judge standing there behind his bench. We do have rotating judges. And we do this in the day room. So they serve lunch there at 12, and everything's cleaned up and moved around. And we set up this little very informal court area with a gallery of about 50 chairs, and that's how we run it. It's real simple and straightforward, and we love it that way. Okay. This is a model that the University of South Carolina worked on for about a year and a half. And this just shows you sort of the flow of sequence from the beginning to the end. I can't read everything on here because the print is kind of small, but at the introduction in item 1, it'll say, hey, client comes in for a referral. And then, each party that has a stake in the client, which should be the public defender, the service provider, the prosecutor's office, we all have a chance to review. I actually will run their criminal history because that will help us figure out what is there that we can help them with. I do expungements also. And a lot of people don't realize in South Carolina, you can have dismissed charges removed at no cost. And that will help clean up somebody's record. A lot of the crimes that people get charged with are 30-day offenses. They'll get dismissed sometimes when they go to court, but they stay on their record. So when you run the rap sheet, I'm not joking. I've had 50, 60-page rap sheets. And then when I looked at it, there was maybe 1 or 2 felonies on it. Everything else was dismiss, leave to reinstate, vacate, whatever. So it's very good to run through their criminal history as they come into the court because they may not even be aware of the things you can help them with. And again, you can see each step of the way, what happens, what we try to do. And this model was done by a graduate student, and I'll show you a picture of him. But he worked on it for quite a while, and it was a big passion of his. And he went ahead and was able to write a dissertation on it. So, again, if you want to search some more information about it, it's definitely out there and available for you. And of course, you'll get my information probably, and I can certainly share anything you need. Again, future goals. The record keeping, that's a big deal for us. So we started doing introduction orders at the beginning so the court could track certain people. When we had people who weren't part of Columbia City Court, that was completely separate. So we started using the Google document with regards to the application. And now we can filter that in an Excel. We can tell us how many men, how many women, dates of birth, what do they need? What is their primary thing? I can tell all of you this right now. Housing, you might think, is the biggest thing, right? Well, it's not. The biggest thing is a driver's license, followed by housing. And the reason for that is they can't get to a job. They can't get to a house because they don't have a way to get there if you live in an area that does not have good public transportation. So you're going to find driver's license is a common thing. And in South Carolina, we ended up doing driver's license clinics just separate of homeless court to help with that problem. Again, key takeaways, stability, collaboration, lots of stakeholders, and a recovery order. We're trying to reduce the barriers to homelessness. I think I'm getting close to the end here. Did I have my picture? Nope, that's not me. That's the next one. Okay, good. Am I at 25 minutes? I just want to make sure I don't overrun my time. But this last photo here also, again, is us having conversations with larger groups about homeless court. And as far as the program, again, it's growing all the time within Columbia, but also across South Carolina. I think a lot of people are noticing that, homelessness is a problem, and homeless court can help you fix some of the legal things that no one else can fix. So if that's something you're looking to do, definitely would love to talk to you and share information with you. So again, I appreciate the opportunity to share the information on the SLIDE program, and we will definitely hope to share more with you if you want to contact us after the program. As far as funding, someone asked on the chat, we don't receive any funding. We do not receive any funding. Myself as a volunteer, the judge is a volunteer, and also public defenders are volunteers. So we do not get any funding. The service providers obviously are nonprofits, so they have their own separate funding. We just try to help them with things at no charge that we know they're not going to be able to do. They're not going to be able to get a traffic ticket reopened and dismissed so that person can drive down the street legally, and they're not going to be able to clear off a prior conviction from 10 years ago so that person can get an apartment. So those are the things we try to do. We do have some providers who will give us money to help fund expungements, and those are also just outside of homeless court. And I wasn't really keeping up with the chat. I'm sorry. I just want to make sure I got through my material. So any questions you might have, they can be sent to me via my email, which is fine. I think I'm finished now. Oops, that's not my email. Hang on.
Okay. Hello, everyone. Nice to meet you guys. And my name is Levana Dato, and I'm here to talk about CARE Act. So before we start talking about CARE Act has its own terminology, and I just wanted to bring up and talk about a few things that you will hear me saying a lot. You will hear me saying the word petitioner a lot, and that's the person who usually file a petition in CARE Act. The respondent, this is the person who the petition was written on. So these are our clients. Supporter, these are the people that usually support clients to voice their needs, voice their voice. You will hear me talk a lot about care agreement and care plan, and I'll talk more extensively later on about this is really the whole meaning of the care program, to develop a care agreement and care plan. We do talk a lot about stabilization on medication, court order evaluation, graduation plan, and psychiatric advance directive. So these are all things that I will address in this presentation. So what is CARE Act? CARE Act is a Senate bill. It's a legislative here in California, Senate Bill 1338, which established the Community Assistance, Recovery, and Empowerment Act. That was developed in 2023, and it provides community-based behavioral health services and supports the eligible Californians living with specific psychotic or mood disorders through a new civil court process. So the CARE Act program is intended to serve as an upstream intervention for the most severely impaired Californians to prevent avoidable psychiatric hospitalization, incarcerations, or LPS conservatorship. The CARE Act process provides earlier action, support, and accountability for both care participants and local governments responsible for providing behavioral services for individuals. The CARE Act authorizes specific adult person to petition a civil court to create a voluntary care agreement or court order care plan that may include treatment, housing, resources, and other services. One of the things that it's important to know, especially when we talk about accountability, is that the state did establish that the presiding judge of the CARE Act process can also fine counties if counties are not following the process, or are counties that are not really providing the services that they said that they are going to provide. So the presiding judge can actually fine counties $1,000 a day if we're not doing what we're supposed to be doing. So the CARE Act was implemented on December 1st, 2023. That was actually, we had two cohorts. So cohort 1 started December 1, 2023, and only 7 counties participated. And by December 1, 2024, all 58 counties in California had to implement the CARE Act progress. My county, Ventura County, is part of cohort number 2. So we started December 1st, 2024. Okay. So the CARE Act process does have eligibility criteria, and the eligibility is clients must be 18 and above in order to be qualifying for the process with a diagnosis of schizophrenia disorder or other psychotic symptoms. And as of January 1st, 2026, the diagnosis of bipolar disorder with psychotic symptoms also added. The person has symptoms that are severe in a degree and persistent in duration that cause behavioral functioning and interfere, right, with the client's ability to function in daily living situations. The person is not stabilized with ongoing voluntary outpatient treatment. Either the person is unlikely to survive safely or independently in the community, or the condition may lead the client to deteriorate. Participant in the ACT program is the least restrictive. So we are talking about the least restrictive environment, and the person is likely to benefit from participating in the care agreement or the care plan. The legislation also provided us with the criteria of what is eligible diagnosis and defines schizophrenia. So all the diagnoses that you see here, schizophrenia, schizoaffective, schizoform disorder, other specified schizophrenia spectrum, and other psychotic disorder, unspecified schizophrenia spectrum and other psychotic disorder, and bipolar disorder with psychotic features are all included. What is excluded is brief psychotic disorder, delusional disorder, schizotype disorder, personality disorder, substance medication-induced psychotic disorder, catatonia associated with another mental health disorder. And what doesn't meet the criteria is psychotic disorder due to general medication condition, catatonia associated with another medical condition, major depression with psychotic feature, or any other diagnosis. Eligibility is determined case by case. It's really important to emphasize that homelessness and mental health alone are not enough to meet eligibility for the care program. So what are the rights that the respondents have, our clients? So once the CARE Act proceedings have started, clients do have rights. They have the right to be informed of the proceeding. They have the right to take part of the proceeding. They have the right to be represented in all stages of the process. The court will appoint an attorney for the respondent who will contact the respondent at the beginning of the CARE Act proceeding with no cost. The respondent does have the right to replace the court appointment attorney with their own attorney. And if they choose to do that, they may need to pay for that. The clients do have the right to request the presence of any family member, a friend, or any other supporter without waiving the right to keep the hearing closed to the rest of the public. The respondent have the right to choose a person to support them through the CARE Act process. That's actually called, that person is called a supporter. Petitioners also have rights. Oh, I'm sorry. So petitioners do have rights also. If a petitioner is someone who lives with a respondent, right, they have the right to participate in the initial hearing to determine if the clients meet the criteria for the CARE Act process. They may have ongoing rights of notices based on court's discretion. They may be allowed to participate and engage in the respondent's care proceeding if the respondent agrees to it. And all other petitioners have the right to make statements at the first hearing, which is really nice because that's actually how the judge starts the CARE Act process. They will ask the original petitioner to say something about why they decided to go through with this process. So who can file a petition? So in CARE Act, there is many paths that lead to the process. And the paths do include family members, so a person who lives with a respondent can file a petition, a spouse, a registered domestic partner, a parent, a sibling, a child, a grandparent of a respondent, a person who stands in a place of a parent to the respondent. Many other community people can file a petition, like a director of a hospital or their designees, the director of public or charitable agency or their designees, as long as they know the clients for over 30 days and providing services for them. The respondent themselves, the client, can file a petition if they feel like they are not getting the right services that they felt like they need to get. The director of a county behavioral health or their designee can file a petition. A first responder can file a petition. A judge or a tribal court located in California or their designees. And any licensed behavioral health professional or their designees, as long as, again, they know the clients and provided services within 30 days. What we're looking at is the CARE Act process flow. And the CARE Act, again, it's a civil court process. Everything starts with a referral. So someone file a referral or someone file a petition, right? And then that goes to the court. The judge then has something that's called prima facie determination. The judge read the petition and determine if it meets the criteria or most likely meet the criteria of a CARE Act. And if yes, they will schedule the first initial appearing in court. During that appearance, if County Behavioral Health was not the original petitioner, the judge will substitute the original petitioner with County Behavioral Health and then order us to do our own investigation. Then it will go to hearing on the merits. That's the hearing that actually the judge fully determine if the clients meet criteria for CARE Act or doesn't meet criteria, and it's based on behavioral health reports regarding that respondent. After that, we move into case management hearing, and that's the hearing that we talk about a care agreement. And I'll talk more about it later. And after that, there is a set of progress reports hearing, because CARE Act is usually a year-long process. And after that, we will go into a graduation hearing, or we will decide to continue providing services to the client. Okay. So what happens during the care process? So as I said, once someone filed a petition, the court reviews the petition. The court has 5 days to review the petition and determine if the client most likely meet the criteria. If they do, they will. If they don't, the court will dismiss the petition. At this point, behavioral health is not in the loop. Therefore, we would not know that the petition was filed, and we will not know that the petition was dismissed. This is all confidential, so we have no idea what happens. However, if the judge decides to accept the petition, we will get a notice that initial hearing was scheduled. If the respondent is found eligible, the court will work with the county, the respondent attorney, and volunteer supporter to kind of connect to mental health services, behavioral health services. And the connection is usually happen either through voluntary engagement, which is called the care agreement. And if the client is refusing services, but there is a lot of concerns and a need, the judge can actually order us to enter a care plan, which is ordering the clients for services. If it's not likely that a care agreement will reach, the judge will order behavioral health to do a clinical evaluation. If the evaluation finds, again, the client eligible, the court will order a care plan. And after that, there is a series of statute hearings, progress report hearings, to kind of let the judge knows how treatment is progressing with the client and also to let the judge know what services the county is providing to the judge, because again, we are being held accountable for services. At the 11-month mark, there will be a 1-year statute review hearing to determine next steps. Next steps include the client can either graduate from CARE Act program after a year. The client actually can ask to participate for another year if they want. They can go to the judge and tell them how much they're benefiting from the program and ask for extension. It's important to know that CARE Act is a 2-year max program. So the client can only request 1-year extension and that's it. After the second year, we have to terminate and connect them to other services. After graduating from the care process, the participants remain eligible for ongoing treatment and supportive services and housing that the county can provide. Supporters are having a really big role in CARE Act. So in the care process, each respondent can choose a supporter, known as volunteer supporter. These are not paid people. The supporter is an adult who ensures that the care process respects the respondent's rights and choices. The supporter partners with other members of the care team, including the respondent, the county council, PD, and the judge. Supporter is an adult chosen or approved by the respondent and should be someone they trust. The supporter must be available to attend CARE Act hearings and appointments. So it can be a friend, it can be a family member, it can be a faith leader, it can be a mentor, a person who has lived experience with mental or substance use disorder. It can be a county behavioral health agency employee. It can be a social service provider or any other person. The supporter has an important and challenging job. They support the respondent as their natural party and ensure the respondent's voice is respected. They are helping the respondent understand, make, and communicate decisions and express preferences through care proceedings. Offer the respondent a flexible, supportive way to maintain decision-making authority over their own life by developing and maintaining voluntary support systems, and uses the support decision-making framework to increase the respondent's ability to make their own decision. The petition filing process. So right now in California, petitioners must complete the CARE Act form. It's called the 100 form. And it can be found in any website of the courts or any website of any county. If the county is the petitioner, we have a new form now. It's called the CARE 102 that the county can complete. However, if the petition is filed by anyone else that is not county, they have to complete a CARE 100 and they have to complete a form that's called CARE 101. The CARE 101 must be completed by a licensed mental health clinician because the CARE 101 provides a lot of clinical information about the client's symptoms, diagnosis, and if they're meeting the criteria for the CARE Act process. There are places that the form can be found, and I place them here. Right now in our county, in Ventura County, California, we don't have an e-filing, electronic filing. So people who wants to file a petition have to do it by hand delivered. They actually have to go to the courts in Ventura County and file the petition there. If the petitioners needs help filing the petition, completing the form, our courtrooms have something that's called self-help, and they are prepared to help completing the form and help with the filing. The filing doesn't cost any money. So what is a care agreement? You heard that words a lot. So a care agreement or a care plan are documents that specify services to support the respondent's recovery and stability. A care agreement is voluntary agreement between the respondents and county behavioral health after the courts had determined that the respondent is eligible for the care process. If a care agreement is not reached, the court may order creation of care plan. A care plan includes a range of community-based services and support ordered by the court. The care agreement or care plan are essentially the exact same document, but care agreement is voluntary, care plan is court order. That's the only difference between them. So what does the care plan or care agreement have? We have 4 components. We are offering our respondents behavioral health services, both mental health services and substance use disorder services. Another part of the care agreement is medication. So we are offering obviously psychiatric services and medication stabilization. We are offering housing, that's a big part of the care agreement or care plan, and any other funded social services, case management services. So the way we do it, we usually sit down with the respondents and the care agreement and say, hey, these are all the services that we can provide you. What are you interested in, right? We are going to respect the client choices and decisions. Clients do not have to agree to everything on the care agreement. Again, we can start very slow. If a respondent comes and say, right here, my priority is housing, we will focus on housing. A care agreement or a care plan is a fluid document. We can always amend, we can always change, we can always add, right? If we found housing and now the respondent is saying, hey, I'm ready now for behavioral health services, like great, let's add that to the agreement, right? So there is no pressure that everything has to be done at the same time. Like I said, housing is an important part of the CARE Act process. Obviously, it's part of the care agreement. It's something that the counties are obligating to offer. In California, we have several funded streams that we can use. We can use the bridge housing funding. We can use licensed adult and senior care facilities and supporting housing. One of the things that the legislation did for CARE Act is that they put all CARE Act participants, clients, as a priority. So if I need to find housing to a client, they jump up to the priority of the list to get permanent housing. One of the things that we also strive to try to do with our respondent is a psychiatric advance directive, which is a type of advanced health care directive. It is a self-directed legal document that states the person's preferences and provides instruction of mental health treatment in advance of mental health crisis. Once we have it, physicians, hospitals, and other providers should refer to the psychiatric advance directive in situations that the respondent is unable to articulate their own care preferences. It can be incorporated into ongoing mental health treatment, serving as blueprint of the individual's preferences regarding their physical and mental health, and it can be revoked by the respondent at any minute. One of the things that were added this year is Senate Bill 27. It was signed by our Governor Newsom on October 10, 2025, and we were ordered to start January 1, 2026. So the amendments that were added to the CARE program is we added bipolar 1 disorder with psychotic features as eligible diagnosis. It's also provided clarity about what is clinically stabilized on ongoing voluntary treatment. Because if respondents are being referred to the CARE Act process, but they are already connected to services and they're already stabilized in the services that they're receiving now, CARE Act may not be for them. right? They are already receiving the treatment. It does provide a process by which certain courts referrals can constitute a care petition without a separate petition from being filed. So that's kind of confusing. Prior to January 1, 2026, there are 3 courts that can actually make direct referrals to the CARE Act process. It can be MIST, Behavioral and Mental Health Court, it can be LPS court, or it can be AOT, Assisted Outpatient. But in order to do the referral, someone actually had to generate a referral to County Behavioral Mental Health, the CARE Act program, and then the CARE Act program investigated and filed a petition. With this new court, the judge can order the client to be evaluated by CARE Act, and that order alone functions as a petition. So it's shortened the amount of time that the client is being investigated. It's allowed criminal courts to consider care referral earlier for individuals found incompetent to stand on trial. And it's allowed nurses, nurse practitioner, and physician assistant to complete an affidavit in support of care petition. So again, it's allowing more flexibility for people to be able to nominate for the CARE Act program. Care court flow. So this is the flow actually that's happening right now in our county. Like I said, there are 3 courts that can make a direct referral for the CARE Act process. So an AOT judge can request a client to be screened for the CARE Act process. Once the client is screened, right, if the client is eligible for the care program, the AOT staff will complete a referral, the care program will send the referral to us, and the client will stay at the AOT court until the CARE Act court accepted the client formally. And then the case will be dismissed. With criminal court, it's the same. The court can make a direct referral, and now we have a parallel process. While the client is still investigated to see if they meet criteria for the care court, the mental health court will have progress hearing until a conclusion is found. And an LPS judge can also order their clients, conserved clients, to step down or be assessed for CARE Act program to see if they can be stepped down for that program, which is very unique because a client then can be conserved while the CARE Act program is investigating the client to see if they can meet the criteria, eligibility criteria for the CARE program. And if yes, the judge may terminate the conservatorship. So I know earlier there was a question with homeless program about funding. CARE Act funding is interesting. So we can bill medical for all of the services that everyone bills medical, right? Individual therapy, group therapy, psychiatric services, case management. But the legislation also created separate funding for just CARE Act. So all the court proceedings are actually being paid or claimed very differently. When that claims go straight to the state. So court hearings time, court reports, outreach and engagement. And outreach and engagement actually include us trying to locate the clients at their community. Sometimes we can't find them. Sometimes we have no idea where they are. So any attempt of outreach and engagement, including family members, we can actually claim to the state. The state also said that clinicians or behavioral health practitioners can give the clients notice of their court, right, when the court appearing is. In our county, in Ventura County, right now we are not doing that. We are leaving that to county council to serve the clients. We are trying to separate ourselves from doing that because we really want our clients to know that behavioral health is there to support them, and we are not serving them, and they think that it's something punitive. And we are obligated for data reporting. And there is a lot of data that the state is collecting every month about each client. Again, all of these 5 functions are being claimed to the state. Um, it's also important to note that all CARE Act proceedings are confidential, meaning that in the statute actually specify that all CARE proceedings, meaning all the court hearings, are confidential. It's behind locked door, and it's literally the judge, public defender, county counsel, and behavioral health, and the respondent at the table, and that's it. No one is allowed at court. It also means that, sometimes at courts there is a list of clients that are going to be, right, a list of people that are going to be heard or during that court day. With CARE Act, we don't have that because it's confidential. No one knows who is the CARE client. And all documents of CARE Act are confidential too. So here are some resources for you. You can find a lot of information about CARE Act. And that's my presentation.
Okay, so thank you so much to our presenters for all of this incredible information. One of my favorite things are logic models, flowcharts. You both had them in your presentations, and those are so helpful. So yes, folks, we will be sharing the PowerPoint slides. If you registered for this event, then we will follow up to that email address with slides as well as the link to the YouTube channel once this is posted on SAMHSA's YouTube channel. So you will be able to look at those slides a little bit more in depth and see some of those flowcharts that might not have been so clear on your screen, but you'll be able to pull those slides up directly. Okay, so we've got a lot of questions, no surprise there, but I want to just see what we can go through that would be common for both Levana and Hans, and then there might be a few specific questions for each of the courts that we'll want to answer. So let me just take a look, and it looks like Hans did spend some time during Levana's presentation responding to some questions. So I do want to just maybe start with a question for Levana, since this came up quite a few times, and I know that you are able to answer this. So because you oversee ASSIST and the CARE Court program. So a lot of folks were asking, what's the difference between your AOT program and the CARE Court program? So could you just explain what differences exist there?
Yes, so first of all, the criteria is slightly different. With AOT, it's capture all diagnoses. With CARE Act, again, we only can write, we are very limited with the diagnostic criteria. Only schizophrenia, spectrum disorder, or bipolar 1. And the second one is that with ASSIST, one of the criteria for ASSIST is that you must have 5150 hospitalization in the last 3 years or one aggressive act in the last 4 years. That criteria does not exist with CARE Act. So I think these two, and actually the path into treatment. Like I said, with CARE Act, you saw that there are many people who can file a petition, family member, law enforcement, other charitable. With AOT, only the county can file a petition. No one else can file a petition. So these three probably are the most that differentiate the two programs.
Would it be accurate? And I mean, this is a question, but would you characterize it as CARE Act being maybe less intense and AOT being a little bit more intensive?
Yes, that's very accurate. AOT is considered a higher level than CARE Act.
Okay, great. Thank you for that. So one question that did come up during Hans' presentation, and I know you answered it in the chat, but I just thought it would merit discussion because of just sensitivities around the stigma associated with homelessness. So there were a few folks that asked, is there a stigma associated with calling this court a homeless court? What should we be thinking or saying about that? And so just curious, Hans, to get your thoughts on that.
Okay. Yes, there is a stigma. This became very evident when we did our driver's license restoration clinics If anyone wants to know about those, send me an email. But anyways, at those clinics, we realized in South Carolina, no traffic offense can be expunged except one. So when we tried to look at people's driving histories and see if we could help them, the only way we could actually do that was to see if we could put them into homeless court. And several people did not feel that that was appropriate for them. And I think it really had a lot to do with the name of the court. Most of the clients that do come through the program were living on the street or had previously been homeless. So it's not a stigma for them, but it can be a stigma for somebody who is in jeopardy of homelessness because they're going to lose their job. They can't get the promotion at work. They can't even get hired, or they've lost their previous apartment they lived in for 10 years because the rent went up. And when they go to look for another apartment, the landlord says, no, you have a prior check fraud. We're not renting to you. And I can tell all of you that is sweeping this country because corporations bought a lot of property and they set the agenda for who they rent to. So you have a lot of that. And so they weren't homeless in the past, but they risk being homeless. And sometimes they don't always want to identify because they do think there's a stigma attached to it. So I've talked with Kylie Sutton. She's like my alter ego on the public defender side. And we have talked about name changes. We just aren't sure that that would hurt the court in the long run because we are there to serve that homeless population. Do we want the public to identify with that population because that's who we're trying to help? And I think it shows when they say the city doesn't do anything, the state doesn't do anything. I want to say, yes, we do. And then I can point to homeless court in Spartanburg, in Greenville, in Charleston, in Rock Hill, in Florence, and say, yes, we are doing this. We're doing this all over South Carolina, and they know it, like they see it. And I think that makes a difference. If I just said quality of life or something, I'd have to explain that. I don't have to explain homeless court. So it is a balance, right? It's a weight, and you need to decide what is best for your court. Like, what do you want to call yourselves? Like, I love the CARES court thing. Like, I do, because when I read it, I was like, oh, I need to learn more about this because it says care. And I said, we care about people. But, so yeah. But yeah, it's a stigma. Definitely a stigma.
Well, thank you for that. And you also answered in the chat, but I thought it was an interesting distinction and clarification. Because I think sometimes folks feel that, we're not holding people accountable enough. And so someone asked what happens if the person is terminated from your program, but you had dismissed charges for them. And your response was, we only dismiss after graduation. Can you share a little bit more about that, like how you all decided to set it up that way, and how you work to help people remain accountable while supporting their movement forward?
Yes. Okay. So I said at the very beginning, it's not a traditional treatment court, right? So a lot of times in a traditional treatment court, someone's going to plead guilty to enter the court, or they can enter the court ahead of time before a resolution of their criminal case. 90% of the people that come to us, their matter was handled a long, long time ago when they were living on the street or in their past. So we don't get a lot of pending current cases. The pending current cases we do get, they do have to complete the program, and then it's dismissed as part of that completion. It's the older cases. They've already pled guilty. It's on their record. If they graduate, we will do a consent order and reopen and dismiss. So that's the carrot. And guess what? If they get withdrawn or they decide to walk away, it's their conviction. It's already there. So I didn't want anyone to think that we do things halfway through the program. We don't. You either already have a conviction and we're going to help you with it, or you don't have a conviction and you need to finish either way because the judge wants to know, are they done over there? Have you all worked through everything? And the officer will dismiss. So yeah, you don't have to worry about people not being held accountable. But if you have a shoplifting or a check fraud or public drunk or something from 2012, we've seen stuff from 1997. And that person just wanted to be able to clean it off their record, and they weren't eligible for an expungement because the category only gave them one 30-day offense in their whole life. And we understand that that's a different life, right? That's a different life. So I love the fact that we can do that. I think it's incredible that we can use the power of the pen with the judge and make something happen that no one else can do. So that's why I enjoy my job so much.
Well, thank you for that. So we did have a couple of folks chime in the chat, and I just thought it was worth it to just kind of read these out loud. This is in regards to the names of the courts, and so someone said that community court is the preferred name. Someone said their name of their program is Outreach Court, and then Gabriel shared that their sheriff's department changed the name of their services from After Incarceration Services to All Inclusive Services. And that's really cool that it's been helpful with opening up services to folks who weren't necessarily incarcerated there. So another thing that was brought up in the chat is the reality that some homeless courts do require that folks are arrested prior to accessing a homeless court, and that too can contribute to the stigma associated with these courts if that arrest and that criminal involvement is a requirement. Whereas that's where we think the Columbia model is a real model in that folks don't have to come through an arrest in order to access the services you all provide. So that being a really wonderful thing. Speaking of criminal charges, there was someone asking, are criminal charges required to participate in the Care Court program?
No. So one of the paths to get into care process is having, right, the first felony incumbent to stand on trial or misdemeanor, but that's only one path. The judge can order clients to be assessed for care court. But like I said, there is many other paths, right? I mean, we have clients that don't have any court involvement, but family members feel like they really need the help. They didn't get that help up until now. So they are trying to connect them to services. The beauty of the program is that one of the things that I feel like most counties are being ordered to do is it's a wraparound program, FSP wraparound program, and we act as an act level modality. So we are a multidisciplinary team. We are field-based program, right? So most of the services are being located at the community, trying to locate clients, trying to outreach, providing all services at the community. So not all clients have to have any criminal history.
That's helpful. And there were a few folks asking about your success rates through the Care Court program. Would you happen to have any of that information handy?
So I can tell you again, we just started in December 2024. So our program is literally running a year and a half, right? And it's a year-long program. So I think we are seeing the fruits of our labor now. We have 4 clients that recently graduated. Up until now, we had 140 referrals/petitions filed. And right now we are serving about 90 active clients. Out of them, 4 just graduated. And we have 4 that requested to continue a second year. And we do have dismissal because there are times that we just can't locate the clients, or sometimes the clients need a higher level of care. So we noticed that, about 75% of the petitions stay with us.
That's impressive. All right. Let's see. There were a couple of other questions. So someone did want to ask specifically, it's a pretty specific question, but if a client is, this is for the Care Court program, if a client is referred having been found incompetent to stand trial, are the charges dropped at the time of the Care Court referral? Could you explain that?
The charges will drop the minute they had the hearing on the merits. The minute they were accepted to the program, then the charges will drop.
Great. Okay. All right. So I think that another really wonderful question just came in. You know, many of us struggle with engaging clients, and they may choose to engage at a certain level for a myriad of reasons. So using motivational interviewing and all of the tools to get people engaged is a constant work for many programs. So I just want to ask both of you, Hans, we could start with you. What are the processes that your court uses for people who might be struggling to engage? And if a person isn't, carrying their end of the bargain or showing up or doing the things they need to do, what kind of strategies do you all use to bring that person a little bit more into the process?
Well, the applications can come from 12 to 14 different service providers. So that's the first step. If that case manager doesn't or cannot maintain contact with that individual, they're never introduced to the court. So we might have 100 applications in 6 months, but we're only going to have 40 introductions. So that's level one. After they're introduced to the court, they generally only stay engaged with the program for 60 to 90 days because, as I said during the presentation, they're coming to us like, I only have one more thing I left that I have to do, right? They're coming to us to go, I need to get my driver's license back. I need to do this. So they've already done so much work. So all we do is say, what do you need from us? How can we help you legally? How can we fix something for you? So usually they stay engaged, right? The driver's license issue is not going to go away. The employment issue is not going to go away. The housing issue is not going to go away. So we don't lose people that often. We have had 3 or 4 that voluntarily just withdrew because they didn't want to, keep it staying involved. But we only meet once a month, and the public defender will check in with them before their introduction, make sure they're on board. We have people introduced who are at work, right? Because we don't want to stop the process. So they may physically not be in court, but we announce them, we clap for them, we welcome them. And then maybe a month or 2 later, we're ready to graduate them because they've done all that work behind the scenes. And all they say to us is, I really just need to get that pedestrian in the roadway ticket off my criminal history. And the judge says, that's fine. You graduated. Good luck. We do it. So it's different for us. We don't have a lot of people drop away because when they come to us, that we're it. This is the end of the road. They have to get that done. So that's why they come to us. So thank you.
For us, again, we are multidisciplinary treatment team. So on our team, right, we have clinicians, we have engagement outreach people, I have peers. So we really attempt to locate the client in the community and see, who can connect to that client. Sometimes the respondent will connect to a clinician, sometimes they'll connect to a peer, right? Trying to kind of it's not also a one-time thing. It's a process that can take months. So we know that engagement can be slow with some people, and that's fine. We respect that. Again, we don't put any pressures. We never go to respondent and say, we have to sign a care agreement by this day. No, right? We will rather go to a judge and say, give us an extension than put any pressure on respondents. But the beauty of the program is that we can offer so many services: behavioral health services, substance abuse services, housing, and case management. And we do tell our respondents, it's really the sky is the limit. Whatever you want, ask us. We may be able to provide that. You never know, right? And we had some requests that we were able to give that. If that's the carrot, let's do that, right? I mean, we are all in. We would love to provide the services. We have peer supporters. I have 2 peer supporters, and I want to say that they are wonderful. They have lived experience. They know how to talk to the respondents, right, and connect with them. I feel like that helped us a lot. The other things that my team and I worked really, really hard on is the collaboration. We have amazing collaboration with the jails here in the county and with the hospitals. So when our clients are in jail, we are in jail at least once a week, meeting with them, again, telling them we are not giving up on you. We are here. We want to tell you we'll be here when you are out. We're coming to see you every week because we still want to know what are the needs. So when you are out, everything will be already ready for you. Right? The same with the hospitals. We are always there with them. We are present. And I think that makes a lot of difference.
It really does. So let's see, just reading through the chat right quick. So funding comes up again, and I know that you answered this in the chat, Hans, about funding and how many of folks in your program are voluntary. And there's also homeless courts set up in other jurisdictions of South Carolina. Do you have any sense of how other programs might be funded in South Carolina? And how did you get support of your offices to devote time to the homeless court?
Well, ironically, I did not volunteer for homeless court. I was simply directed that that was something I was going to do. And sometimes when that happens, you just go, "Hey, I really like this." So I've been doing it a long time. But I think from the public defender side, there should be funding that is needed because the workload for the public defender is much, much greater than for the prosecutor. I'm just there to say yes to everything, basically, and sign off, right? And the public defender is sitting there with the person. There's 2 or 3 public defenders involved, and they're trying to say, okay, we're going to go ahead and find your birth certificate. We'll get your social security card. We'll do all these things for you. And then at the end, when you graduate, if we need to help you with that ticket or that old conviction, we can do that too. I don't know. I'm not aware of additional funding for homeless court, although we all have the ability to apply for grants. And some of those programs that the public defender could apply for may help cover the cost. They have a social worker who also works directly with the homeless court clientele. And I don't know if her funding came from the county or if it might have come through a grant. So I would imagine people do have some options, but the judges are just in their normal workday. So it's not after hours and it's not on the weekends. But they do just go in a rotation, and we get a different judge sometimes every couple of months. And they all love doing homeless court because it's like a happy experience. But yeah, for the prosecutors, myself and Jack, we don't get any additional funding for our work there. We just like to do it. So.
And yeah, I think that it's important to recognize how oftentimes when we start these kinds of programs, there isn't funding available, and it really is a all hands on deck kind of approach. But eventually, we want to normalize funding for these kinds of services, and so just wanted to put that out there that we're not advocating for folks to now volunteer all of their time, but maybe there's another dissertation waiting in the wings here to look at the cost savings or the cost avoidance that has been achieved because of all of these cases being resolved and people being able to move on with their lives. So that's a really remarkable thing to think about. So for Lavana, we did get another pretty specific question about incompetence to stand trial. And so just let me know if you want to answer this now or if you want to follow up later. So someone asked, when incompetent to stand trial misdemeanor patients are too ill to be able to consent to care court, are they assessed by anyone for danger to self, others, or grave disability? What happens next?
So I can answer, again, our county. So our county has an embedded psychologist in the mental health court, in the ISD or the FIST court. And their role is really to kind of, once the judge determines that it's a possibility, the judge will order them automatically to do 3 things: assess them for CARE Act, AOT, and gravely disabled. And that psychologist then determines the path, right? So yes, if someone is too ill, they will probably determine the gravely disabled path prior to care court.
And then another question that came up was about the different plans that you talked about. Would it be possible to share a template or a copy of those?
Yes, I'll be able to share a care agreement template if you want. I can send it to you, Melissa.
Okay, and so before we do that, could you just maybe briefly describe what like major sections that are included on those plans?
Yeah, so we have treatment section, which include behavioral health services, right? Individual therapy, group therapy, rehabilitation. If we have crisis management, right? We also have under that substance use treatment, all the services that the county is offering, and then the clients can choose if they want any to participate in any. Our second section is usually medication management, meeting with a psychiatrist, meeting with a nurse, getting medication. We do offer, again, field-based. So we do have a psychiatrist that may go to the field if needed. The third section is housing. In that section, usually we focus a lot with our clients about, okay, these are the housing that we can provide. Some of them are permanent housing too, right? That's the whole goal. And we can talk to them about the path to how to get there. So maybe, at the beginning, something temporarily until, right, the permanent will get there. But we talk a lot about housing. And the last section is case management, helping linkage to medical, social security, right? EBTs. Clients can tell us, I think for my recovery, I need to go to the gym. Like, we'll put that, we'll pay for it. I need glasses, great, we'll take you. Anything and everything that is case management, we will help with. So these are the 4 components of a care agreement.
Thank you for that. Okay. All right. Let's see. So I think we've answered a lot of the questions here that are general. Okay. Lavana, is there any prioritization for pregnant individuals or people who have recently given birth or have kids?
It doesn't really matter where the referral path comes in. Everyone gets the priority they needed. And also the CARE Act process does have time limits. So like I said, if a referral comes from outside, we have 30 days to investigate. If the county initiates, we only have 14 days. So it's really also depends where the referral is coming from. But we take every referral seriously, and we do try to do it in a timely manner because we understand people are in need, and we really want to be there for them and help.
Okay. All right. Well, that brings us to the end of our webinar today. We do have a couple more wrap-up slides for you folks. So for those of you interested in downloading a certificate of attendance, Sam Rogers has just dropped a link in the chat. Just click on that link and then follow the instructions of your device to download the certificate to your device. And you will need to personalize it yourself. You will enter your name in there for that certificate. So please click on that. And we did just also pop up a poll if you would like to provide any additional feedback. We do take this information and consider it as we are planning for future work and future webinars. And thank you so much to all of you for the comments in the chat. We do have a couple of upcoming events that we would love to have you join us for. In July, we are starting a series of webinars focused on reentry and touching on housing issues. And so on July 7th, we will have Julia Orlando presenting on bridging reentry and housing and providing strategies to address homelessness at the reentry touchpoint. And then on July 23rd, we will have a presentation talking about the risk-need responsibility framework and how that can apply to reentry as well as supporting housing. So those 2 events coming up in July. Watch out for our newsletters to register for those events. And if you have not signed up for the Gaines listserv yet, we will provide that link here on this slide as well as in the chat. Sam Rogers dropped a link to the registration for our upcoming webinar on July 7th. And then he also just dropped in the chat the link to sign up for our Game Center's listserv. This is where you'll get all the Game Center's blast about upcoming webinars, any programming the Game Center is offering, as well as a quarterly newsletter regarding programs similar to what you've heard about today. So we won't overwhelm you, but we really love to share information with you all about what's going on in the field. So if you haven't signed up for that, there is the URL on the screen, and we can move to the next slide. And if you do have any other questions, I know Hans shared his email address in the chat, so you can feel free to reach out directly to him or reach out to us here at the Game Center. You see our web URL as well as a toll-free number. Call us here at the Game Center. We're happy to connect you with resources, help you find information. We do have funding for phone-based technical assistance, so please do reach out if we can help answer questions or connect you with people who could answer your questions. We'd be happy to do that. So I just want to say thank you so much to Lavana and Hans for your time today, for sharing about these incredible programs. They're different. They're on the opposite sides of the country, but reaching the same population and ultimately having the same effect of helping people in recovery, helping them move forward with their lives. And so we just really appreciate your time and the dedication to your programs and the people in your communities that you serve. So, and likewise to all of you joining us today, thank you so much for all of the work that you do in your communities to support those that are in recovery. And hope to see you on July 7th at our next webinar. Have a great evening, everyone.